Greetings to all of you and welcome to joining us. I guess this is our last, our last week of the CIL eAcademy and our last distinguished lecture for this year. And I can't think of a better way to end the series and the year with our guest lecturer today, Diane Tan. And we thank her so much for joining us. I've had the pleasure of knowing Diane for a number of years, and she's a very seasoned and diplomat and lawyer with the Attorney General's Chambers. She is Deputy Director General, responsible for security of the International Affairs Division. But she does a lot, I know. She's just fresh from Dubai and COP28. She's been a negotiator for climate change. She's appeared at the Sixth Committee. She's done international criminal cases as well, involvement. So Diane has a very extensive experience in international law. And today we're really lucky. She's going to be talking to us about immunities from the Singaporean perspective. And we really look forward to listening to you. Thank you so much, Diane. There's much more I could say, but I want to save the time so that our participants can benefit from your lecture today. So on behalf of Patricia and myself, welcome.
Thank you so much, Nalitha. Thank you so much, Patricia. Good morning, good afternoon, good evening from wherever you are in the world. It's lovely to be here. I am very honored and privileged to be able to give this guest lecture to you. But first, because I have not been doing very many virtual sessions, give me a moment to try and share my slides. I did it earlier and I should work this time. Yes, I got it. So in terms of what I'll be covering today, the law of diplomatic immunity and state immunity, a practitioner's perspective and certainly a Singaporean perspective, I thought it'd be very useful to sort of run through really what are the key challenges, the practical realities, and the issues faced by not just actually a Singapore international lawyer for the government, but really any international lawyer dealing with this area of law. Diplomatic immunity is really what I would call the bread and butter work that we do as international lawyers. And we will want to really focus on what are some of the key challenges that we have to deal with in dealing with diplomatic immunities. And one of the key challenges that you're going to see that's going to cut across what I'll be talking about was really how do you interpret the Vienna Convention on Diplomatic Relations, which is a 1961 instrument, 60-year-old instrument, and how do we interpret the instrument in a manner that is relevant for the time that we're living in. So without further ado, I will start my presentation. I will first set the context in terms of just understanding the range of immunities first, and then I'll go on to talk a little bit more about diplomatic immunity. That really forms the chunk of the bread and butter work that we do here in International Affairs Division of the Attorney General Chambers of Singapore, and what's really Singapore's approach to some of the issues that have come up. And then I'll also tackle a little bit about state immunity. But having said that, I will be the first to confess that we deal with a lot more diplomatic issues than we do with state immunity. And so the state immunity section will be a bit limited and will be towards the end of the session. So just in terms of setting the context, I thought it'd be first useful to really set out what are the different categories of immunities that we deal with on a day-to-day basis. The first two that I've splashed on the screen, state immunity and diplomatic immunity, is where we will go into in a little bit more detail. But please allow me at this point to briefly highlight a bit about the privileges and immunities of international organizations and their officials. Now, as you are probably aware, Singapore is a hub for many things. We are a trade hub, we are a cyber hub, we want to be a hub in artificial intelligence, But on top of it all, we're also a hub for international organizations to base themselves in Singapore. And when we have international organizations in Singapore, what also comes about is the need to grant them privileges and immunities. Now, we have a variety of international organizations that are based in Singapore: World Bank, APEC Secretariat, Interpol, WIPO, the list goes on and on. But what I can tell you, and I wanted to just quickly touch on a little bit in terms of the work that we do, is that for each international organization that stations themselves in Singapore, we will always have to spell out what privileges and immunities they enjoy in a separate instrument. This instrument is an instrument that we like to call host country agreements. Now, negotiations tend not to always be that straightforward, but negotiations always start from the common basis of the UN Convention on Privileges and Immunities of the United Nations. So that's always sort of the starting basis from which we will negotiate this privileges and immunities. And depending on the organization that we are engaged with, we will also then refer to the different instruments or conventions that these specialized agencies may have. So big part of the work that we do with Singapore government is actually to deal with these privileges and immunity issues that crop up in the context of host country agreements. So that's actually putting that aside now. I'll get more into a bit about diplomatic privileges and immunities, which will form the chunk of my presentation today. The principal treaty that governs diplomatic relations, I've already actually mentioned it, is the Vienna Convention on Diplomatic Relations, 1961. Singapore acceded to this treaty in 2005. We've also acceded, I think at the same time, to the Vienna Convention on Consular Relations of 1963. And I think I just want to flag here at this point that there's quite a bit of interplay between diplomatic immunity and consular immunity. And I'll get a little bit more into that detail as we go through some of the real life issues that crop up. So just to flag here, for the purposes of today's presentation, we will be referring to VCDR and VCCR. They're quite a mouthful, so that's why I'm not going to use the full term. So please bear with me on that. The other 2 points that I want to make before we sort of do a deep dive into the practice of diplomatic law in Singapore's context, as well as, I guess, in practical context, is really the importance of states practice. Truth be told, as I said earlier, the VCDR and VCCR, they are dated instruments, 1961, 1963. Now, if you read the text of these instruments, you would really realize that, things have moved on from the 1960s, the point in which they were drafted. And it's therefore an essential role of lawyers dealing with this space to really interpret the VCCR and the VCDR in a manner that makes sense for modern times, the time that we are living in. And a large part of making sense of the VCDR or VCCR obligations is really to look at state practice. What is the practice that is prevailing at any point in time amongst the diplomatic corps? And we always ask ourselves, as if we don't necessarily get the answers we need from looking at DCCR, the commentaries to the two instruments, or even textbooks to try and reveal how we should go about interpreting the obligations. The next pit stop for us will be to actually look at state practice. And one of the key questions we ask ourselves as government legal advisors is, are we isolated in the way that we are treating the diplomats in Singapore? Because if we are isolated, then the big question that we have to ask ourselves is, should we actually keep in step with how other people are treating diplomats in whatever particular issue that is at hand? And so state practice actually becomes quite a big chunk of the research that we go into to determine whether or not whatever and however we treat the diplomats is in line with international law obligations. I think the second other very important consideration that we keep very forefront in our mind as we think about law on diplomatic immunity is that of the principle of reciprocity. This is enshrined in Article 47 of the VCDR, where let me just quickly run through what it says. So in Article 47 of the VCDR, it says at the start that the receiving state shall not discriminate between states. However, it then goes on to say that it will not be discrimination if the receiving state applies any provision of the VCDR restrictively, because the sending state has applied a similar restrictive application of the provision. And in a similar vein, where there is more favorable treatment accorded between the two states in question, then that is not considered discrimination as well. And so a large part of the work that we do in the context of the law of diplomatic immunity is actually to think about this principle of reciprocity. In many a times, we have to think about what is the impact of our diplomats, so Singaporean diplomats operating in foreign soil, what will be the impact on them if we take a particular position in terms of the diplomats that are based in Singapore. That is a prevailing consideration that comes through a lot of the advice that we render, because we don't want our Singapore diplomats to be placed in a disadvantageous position, because as a matter of the principle of reciprocity, if we do certain things, then the state in which our diplomat is at could reciprocate and also treat like for like. And we're very conscious about that. So those are the two prevailing themes that sort of underpin a lot of how we go about thinking about issues relating to diplomatic immunity in the context of the advisory work for as a government lawyer. So now turning to just very quickly, because I wanted to give you a sense of how Singapore approaches immunity, I thought it would be useful to also give you a flavor of how do we implement our obligations under the VCDR and VCCR, both of which we acceded to in 2005. Now, Singapore is regarded as a dualist system. I think I did a quick check of the name list, so I know not all of you are international lawyers. So I thought I might just want to quickly explain a little bit about the divide between monist versus dualist divide. So in a monist system, international law and domestic law form part of the same legal system. And since international law is part of the same legal order, it is regarded as incorporated into domestic law. Singapore is a dualist system. So it is a system that regards international law and domestic law as separate legal orders. And international law does not automatically become part of domestic law unless expressly adopted by legislation in Singapore. So in the context of our obligations under the VCDR and VCCR, we have had to enact a specific legislation that's set out on the screen in order to give force of law to the obligations that we have agreed to under VCCR and VCDR. So just a quick overview of, and a snapshot, Singapore and how we incorporate some of our international obligations within the domestic context. So now, in terms of diplomatic privileges and immunities, I thought it would be useful at this juncture to really break through and break down some of the practical realities of what we are dealing with. A large part of the work we do, yes, it's diplomatic immunities in question, but at the same time, actually, we have to be very careful because there is an interplay between diplomatic immunity and consular immunity. To a greatest extent, of course, diplomats get much wider privileges and immunities than consulars. And within even the confines of diplomatic immunity, there are different categories of individuals who are granted different range of diplomatic privileges and immunities. So when we actually have to sit down and determine who gets what privileges and immunities, one of the important questions we actually have to first ask ourselves is, what category does the officer fall under? So that's always the first order question. And in day-to-day business, the truth is that some people will actually wear different hats. So even though you might have a person whose title says Consular General, the person might actually be accredited as a diplomat. And so that sort of finding is very, very important at a very early stage in order to make sure we know exactly who this individual is, what this individual has been accredited with, and then to be able to determine the privileges and immunities that flows from that status. That is one of those, it comes as a surprise to me sometimes, but I have had younger officers who join my office who they just assume because the person is Consulate General, therefore, okay, I'm just going to go straight to VCCR. And we go, no, hang on a minute. You have to go backwards and check, because that Consulate General actually may have been accredited a diplomat. And then if so, VCDR obligations apply, not VCCR. So that's where the interplay between diplomatic and consular immunities come in, but I'm not going to get into the weeds to tell you what the differences are. I think that would just cause me to go way over time. And I realize that time is running out as I speak. In terms of understanding diplomatic immunity, it used to be the case, actually, that the old idea was that the mission, meaning where your embassy sits, is actually a piece of the territory of the foreign state. So it's almost as if it's like, this is your territory, but you've carved out like an area and you've given it to the foreign state. That was a really old idea. It's no longer a valid view or perception of what the diplomatic premises mean. In modern day times, the perspective is that the diplomatic mission, the diplomats, they're all on local soil, national soil, but privileges and immunities are granted to them so that they can function effectively. And that's really the modern day view of how we should regard privileges and immunities. This is captured in the preamble of the VCDR. I've set it out here, so I won't read it any further. But maybe this is also where it'll be useful to just very quickly go through what are the functions. When we talk about we want to enable them to function effectively, we also need to have a good sense of what are the functions of a diplomat. And this is clearly set out in Article 3 of the VCDR. So I won't again go into an elaboration. I've set it out here. I'm happy to share this deck of slides so you have a good sense of what do we expect from diplomats and what we are prepared to give them in order for them to be able to carry out their functions effectively. One of the key challenges in dealing with diplomatic privileges and immunities, and I think for those who just flip open the newspaper, sometimes it happens, sometimes it doesn't, but more often than not in recent times, it has become quite a big deal, is that diplomats don't always behave themselves. That's the honest truth. It happens. And for us, in the context of Singapore, and I will again share with you a little bit of our lived experience, the one thing we do underscore very clearly and actually very strongly is Article 41, which involves corresponding duties of the diplomats. It's a very important balance that needs to be struck. The grant of privileges and immunities has to be weighed up against the need for diplomats to correspondingly respect the laws of the receiving state, and in our case, Singapore. So there are three aspects to Article 41. that I thought I would stress first. I've already said it. We do underscore that diplomats have to respect the laws and regulations of the receiving state. It's also important to underscore the duty not to interfere in the internal affairs of the receiving state. And thirdly, and we'll cover that in a bit more detail because it comes up a lot, the premises of the mission are not to be used in a manner incompatible with the functions of the mission as laid down in the VCDR. So we spend a lot of time in terms of the work that we do trying to reach a careful balance between wanting to give, of course, in line with our VCDR obligations, space for the diplomats to function effectively, efficiently in Singapore. But from the Singapore's perspective, it's always a balance that has been struck where we also expect that they will have to respect our laws. And there are some cases where, the balance, it gets tricky in terms of having to strike it. But therein lies the inherent tension that we face in dealing with diplomatic immunity. And I think that I'll cover a particular case when really this comes out a bit more to the fore. So I will now go through specific categories of diplomatic immunity that we focus a lot more. So you would see that the VCDR is a fairly lengthy document, but really the key provisions of the VCDR that I'll be highlighting for the presentation today, it really centers on where a lot of our attention, a lot of our work focuses on mission premises. The premises of a mission are inviolable. As I said earlier, the premises of a mission is not regarded as foreign soil. They remain the territory of the receiving state. But because the premises are inviolable, they cannot be interfered with. This is fairly absolute. The consent of the head of mission is required before agents of the receiving state may enter premises of the mission. Enforcement agents cannot accidentally or unintentionally enter mission premises that would amount to a breach of the VCDR. Service of legal processes, not uncommon these days, they would also amount to a breach of the inviolability of premises missions. One of the other more proactive aspects of this inviolability is the duty of a receiving state to take all appropriate steps to protect the premises from intrusion or damage. And this, for instance, can be done by heightened police presence should the need arise. And so that's one of the more proactive steps that are taken in order to ensure compliance with the obligation to ensure inviolability of mission premises. I highlighted this earlier. One of the key issues that actually does come up from time to time is premises of the mission being used in a manner that is not compatible with the functions of a mission. Some diplomatic missions get involved in commercial activities. And so one of the key things that we have to look at is to what extent is it really a purely commercial activity, and to what extent the activity can actually be regarded as function of the mission. Is a case-by-case basis, is a factual inquiry blended with the need to look at it from a legal perspective. And that therein lies some challenges because, of course, diplomatic missions may take the view that what they're doing is actually part of the functions, but we may actually take a varying view that, no, it's actually commercial in nature. And that's where some of the tensions could come about. I've put out the pictures, which I think you would be quite familiar with. It's not something that has happened in Singapore, thankfully. But it really does give a sense of the issues that could come up regarding mission premises. So the pictures that I've in the slide is of Julian Assange, the founder of WikiLeaks. Now, I'm not sure whether you're aware, but just to share in case some are not, there was an international European arrest warrant out for Julian Assange at the time for suspicions and allegations of rape and other sexual offences allegedly committed in Sweden. Now, Julian Assange was in London at the point in time, and the UK authorities wanted to extradite him to Sweden. So he took refuge in the embassy of Ecuador in London. Ecuador had given him political asylum. And because of the fact that Julian Assange was in the embassy of Ecuador, and because of the inviolability of the Ecuadorian mission, the UK authorities could not enter to arrest him and to execute whatever extradition requests that had come in from Sweden. Therein lies and really demonstrates the power of inviolability of mission premises. The picture on, well, is my right, is a picture where the UK authorities really could only go in to arrest Julian Assange after Ecuador had revoked his asylum. And in fact, it was the Ecuador ambassador who invited the London police to enter the embassy to arrest him. So there, just to set out in some context, really how powerful and absolute the inviolability of premises can be. One of the key, well, not one of the key, but one of the regular questions that's actually asked of us in terms of, sorry, I should have gone, yeah. One of the key questions that's asked of us, and we advise very frequently, is what happens in a case of emergency? If there's a fire, there's some emergency that needs to be attended to in the embassy, can our firefighters go in? Our view, and I think it's the view shared by quite a number of international law authors, is that because of the inviolability of the premises, actually the firefighters cannot enter such premises without the consent of the head of the mission. That has been the position that Singapore has taken, and that, I think, generally has been what has been the state practice but in practical terms, one would hope that in the event of emergency, the ambassador will do the right thing and allow our firefighters to go in. But it's not an issue that has arisen, it's been dealt with in the not hypothetical scenario that actually comes up in Singapore's context is that of inspections, for instance, in terms of mosquito breeding. I don't know how many of you are familiar with our Singapore context, but we have this virus that is actually quite a serious virus during certain seasons of Singapore. During certain seasons in Singapore is called the dengue virus. That becomes a really big issue, a really big political issue, because many Singaporeans suffer from it. And so there is quite a bit of pressure on the part of enforcement agencies to want to go in to different premises, not just diplomatic premises, but all premises, to check for stagnant water to determine whether or not there's mosquito breeding. So it's a real life question that has come to us for advice on whether or not, can I go in? I'm doing the right thing. It's for the welfare of the public. I want to go in. I want to check for stagnant water. I want to be able to just make sure that the embassy is keeping their premises free of any situation that might lead to the breeding of these mosquitoes that will give rise to dengue fever. But in that situation, the truth is, as I said earlier, the inviolability of premises is absolute. And so it's really difficult for our enforcement agencies to go in. But if there is consent of the ambassador or the head of the mission, then no problem at all. So these are the sort of issues that actually become fairly live issues, and you don't even need to wait for an emergency to happen. It's actually the day-to-day business as usual issues that can crop up. But we respect inviolability of mission premises, and so we will be very, very careful to not go in, and we'll always seek the consent of the head of mission before doing so. So that's for mission premises. Just very quickly, in terms of one of the key elements that we do advise on as well is that of the protection of diplomatic communications. It's arguably one of the most important in my view, because how else would a mission be able to carry out their functions if not for free communications, be it with their counterparts back home or be it with other diplomatic missions. So in the context of the VCDR, it's not just communications, websites, whatever they need to communicate, it goes right down to archives, documents, and correspondence that enjoy inviolability. I think one of the key challenges for us is, where do you draw the line, right? In terms of free communication, way back when VCDR was drafted in 1961, we didn't have Instagram, we didn't have Twitter, we didn't have any of these social media devices that are being used today to communicate. And I think one of the key challenges that we have to deal with in today's context with regards to wanting to ensure the protection of free communication is also to think about, where do we draw that line when these communication platforms, be it Twitter, Facebook, are being used in other manners, which may not necessarily be consistent with how we want to deal with propaganda, right up to how we want to deal with fake news. So these are actually very, very, very current challenges in how we are dealing with this particular article of the VCDR. What is freedom of communication? All communication, some communication, like, where do we draw the line in the age of social media? These are some of the issues we're dealing with in contemporary times in dealing with this particular aspect of diplomatic immunity. In terms of diplomatic bags, that's also another one of those issues that come up quite often. It cannot be opened or detained. A diplomatic bag may only contain diplomatic documents or articles intended for official use. And I think the one thing to be flagged, though, is that state practice that has emerged is that a diplomatic bag may be scanned as a condition of carriage. We see that as a commercial contract. If you want to fly, you're going to have to respect, whatever the carriage airlines rules are. In general, I think one of the key things that has come up in the context of us dealing with diplomatic bags is really that of potential for abuse. Again, it's possible that there will be situations where diplomats may want to bring things in through diplomatic bags, which may not be legal at that point of time. What do we do? How can we open the bag to search if we have information along the lines that they may be coming in with illegal goods? But in general, the state practice here has been that if a receiving state wishes for the bag to be opened on arrival, the sending state will have to consent before the bag can be opened. And the state practice also is that it has to be done in the presence of officials. So again, it's one of those things where you have to have good ties with your counterpart foreign mission, and to really try and get their consent to get around some of these limitations of, well, not limitations, but wanting to protect the inviolability of a diplomatic bag. Yeah, so that's one of the key issues that have come up for us. Diplomats. So this is really the core chunk of a large part of the work we do. Diplomats enjoy inviolability. They are immune from criminal, civil, administrative jurisdiction. They have freedom of movement, of course, subject to national security restrictions. In terms of really trying to better understand, I think, the scope of privileges and immunities that are granted to diplomats. I think I'm not going to go into detail. It's in the VCDR, but I think what I wanted to do is to give you a sense by using a not so good an example to show honestly where the tensions come in when we're dealing with diplomats. Obviously, I think it's quite clear that diplomatic agents, the immunities and privileges that they enjoy are quite wide. They are quite powerful. But there have been inroads made over time in terms of what we can do in the event that there is some misbehavior on their part. One of the key areas in state practice that has emerged in terms of dealing with diplomats is in the context of parking offenses. It is one of the most common forms of diplomatic misbehavior, but the trend has emerged from state practice that actually countries do require diplomats to pay parking tickets. Why? Because there is public outrage from the fact that, from the public's perspective, looks like diplomats are above the law, that they are given special treatment. And those are sensitivities that all of us are alive to. And so in many cases, this is one of those areas where even though the VCDR should be interpreted in a particular way, I think modern times plus state practice has allowed us to evolve how we see the law on diplomatic immunity. So I've set out on the slide here what happens when, I mean, not for parking ticket, but for like more serious cases. What can a country do with a misbehaving diplomat? The immediate thing we would ask for is to request a waiver of the person's immunity. That will be the first step, not always given. And if and the waiver that is to be given must be express and specific to the matter in question, and only the sending state can waive immunity. And when the waiver doesn't come, we can also make a demand that he be recalled back for punishment. And in sort of what we regard as the worst case scenario, if it's a very egregious case and he's not being called back to answer for his misbehavior, then what will happen is that it's possible we will actually declare him persona non grata. This is the unqualified power of the receiving state to ask for the removal of a member of a diplomatic mission. And then once we notify the sending state that the diplomat is persona non grata, the sending state must then recall the diplomat. There is a certain amount of reasonable time before the immunities and privileges extinguish. So we'll give the diplomat a bit of time to leave before we can take action. It varies as to what reasonable time is, but I won't go into that. In terms of what I wanted to share is this particular case. I actually thought, and I realized that it's become such entrenched into the way and the psyche of how we operate and we deal with diplomatic immunity that when I was preparing for this presentation, I did not realize that the case was actually a really long time ago. So the picture of this man, his name is Silvia Ionescu. He was a former Romanian diplomat. And in 2019, he got involved in a hit and run accident in Singapore where 3 individuals were injured in the accident, and one of the pedestrians died. He left Singapore 3 days after the incident took place. And the reason why this, I had, actually, come to think of it, I had actually joined the division in 2009. So this was, I guess maybe that's why it's etched into my memory. But this incident has, in many ways, I would say, scarred how our public views diplomats. The amount of public outrage was unprecedented against the diplomatic community, because there were so much questions being raised as to why he could have gotten away with killing someone, right? From the hit and run incident. And in terms of the amount of public outrage, it didn't just end with him going back to Romania and us answering why he couldn't have done anything about it because he had diplomatic immunity at that point in time. I went back to do some research, and I realized that even though the case was in 2009, we kept up over the years, keeping track of what his court case was, because he was also charged in Romania for the same offenses. And the press in Singapore kept track of every single detail of this diplomat, right up to the point I think where he passed on in prison in 2014. But this episode really taught us that it is a very, very sensitive, and it's a very, very delicate issue in terms of how the public perceives diplomatic immunity. It's a real challenge, and I remember us having to vet all sorts of MFA spokesperson press releases, comments, to try to explain to the community what diplomatic immunity is about and why we need to accord diplomatic immunity. I'm trying to get into all those sorts of reasons, and it wasn't easy for the public to understand it, because from the public's perception, it's also almost as if you're treating a category of people above the law, and they are given special treatment, and they got away with murder, basically. And so this is really one of the most egregious cases involving a diplomat, and it, up to today, actually weighs very, very heavily in the minds of how we go about dealing with diplomatic immunity, and bearing in mind the sort of tensions that could come about when thinking about this issue with our local population. So, for instance, there were many issues which I can't get into because I realized I'm running a bit off time. But there were many issues that we got into in terms of trying to deal with how do we treat diplomats in the time of the pandemic. In times of pandemic, obviously Singapore, and we were not alone in it. We were imposing all sorts of quarantine restrictions, movement restrictions that you had to go. Feels like such a long time ago, but in Singapore, when you wanted to go into a mall, you had to open up an app to use something called a safe entry to get in. And there were all sorts of questions raised as to, well, if you do that, are you actually limiting the freedom of movement of the diplomats? But at that point in time, knowing full well that the public will react if we exclude them, it was a real challenge to sort of balance out, like, okay, I think diplomats need to be subject to a certain amount of restrictions along with the whole population, because they could contract COVID too and spread it around. That sort of thing was all about public health. But at the same time, striking enough of a balance such that we still are respecting what our obligations are towards them in the context of the VCDR. So it's those sort of tensions that come up to the fore the most, actually, whenever we deal with diplomatic immunity. And it's really our local population's response and their sort of knee-jerk reaction to why are we treating this category of officers above the law, which is not what we necessarily do, because like I said, they have to respect the laws, but if they don't, then we'll have to take action. So again, it's one of those things where it weighs very heavily on our minds as we go through the issues relating to diplomatic immunity. So very quickly, so I'm very conscious of the time, I wanted to leave time for Q&A. I'll just very quickly go through state immunity. It's, I'll confess, not as much work for us on state immunity as opposed to diplomatic immunity for the Attorney General's chambers in Singapore. But very quickly, state immunity. So under international law, a state is generally immune from the jurisdiction of the courts of another state. And this immunity allows states to be able to carry out their functions effectively, allows smooth conduct of international relations. One of the key things of state immunity is the perennial issue of which school of thought do you belong to? Do you take a restrictive approach versus an absolute approach to state immunity? It's up for each state, of course, to decide which approach works best. But for Singapore's context, and this is enshrined in our State Immunity Act, we adopt the restrictive approach, which means that for us, immunity is only accorded where the acts of a state do not involve commercial activities. So that's clearly enshrined in our State Immunity Act. And as far as I am aware, I do think that it is a fairly widely adopted practice of restrictive approach. But I think where it differs is that how you go about recognizing what is the exceptions to state immunity and your definition of commercial. And that's where I think there's quite a bit of variance in terms of state practice. I think what I wanted to end with in the context of state immunity is that it's an incredibly fascinating area of law, which I don't have time to get into because I realize, well, actually, I wouldn't have had time to get into at all. But it's really interesting because whilst the immunity works and its adoption of international law on the international plane is actually applied in accordance with national law and local courts, where it actually gets its hearing. And so this is one of those areas of international law where you see a very complex interlinkage between international law and national law. And for us, it's actually really important to have a very, very clear understanding and a good keeping abreast of what's going on with other countries in order to understand, whilst I may adhere to a restrictive approach, but if I am pleading state immunity and it's before the courts of a country that adopts a absolute approach, how do I resolve that conflict? And it's quite important that we keep track of developments in various areas. And I think here I thought I would just share one of the interesting things that we are monitoring very closely on our end is one of the key players who actually, I think for a long time, applied the absolute approach to state immunity was China. And we're watching the space very closely, but China has actually passed a new law that will apply the restrictive approach to state immunity, and it's coming into effect on 1st of January 2024. As a result, foreign states will not be granted immunity in respect of commercial activities. This is quite an interesting development for us to watch out for, no less, in case we have complete state immunity in Chinese courts. And we also understand that the Chinese government has indicated that the same approach is going to apply to the special administrative regions of Hong Kong and Macau. So all in, quite an interesting development to look out for. The exact implications, I think I will have to be invited again as a guest speaker to share on what are the implications for us and the world. So with that, thank you so much. I've come to the end of my presentation. I'm happy to take any questions.
Thank you so much, Diane. And with pleasure, we would love to have you come back as a guest lecturer, speaker, and continue this really fascinating lecture you've given on Singapore's perspective. And I think you've been able to so masterfully combine what the convention says, the black letter law, but against the reality and the multiple balancing of interests that come into play. And I just have to say, the issue of the public is really important. And right now in Turkey, there's a huge public outcry over an incident involving the son of a president traveling on diplomatic passport who had a fatal hit and run and was allowed to leave the country before, and it's a huge public outcry. So you're absolutely right on that. Anyway, this was really wonderful. And I hope you will allow us to go a little over time because we do have questions. And indeed, I think the first couple of questions you already answered. Let's see. I saw there was a question from Mr. Kai Lu Lo concerning the principle of reciprocity. Is that stipulated in the Singaporean statute? And you mentioned already the immunity statute. And the second question had to do with restrictive doctrine. And you answered that, but I believe he's asking whether that also flows into IO, such as in the US. And I'm just going to give you the questions. I think it's easier to do that. This is from Ethiopia, Mr. Ajema Meletadadi. And it has to do with the premises, mission premises. Does it mean that it is possible to violate diplomatic premises by the receiving state when illegal acts are committed within diplomatic premises? Why don't I let you answer those? And there's one more from the Philippines, but I don't know. I tend to forget after a while, so I'll leave it at that, and we'll get to that after you answered those questions.
Thank you so much, Nalofa. So in terms of the first question, is the principle of reciprocity expressly stipulated in Singapore statute? Just to flag that the principle of reciprocity is one under the Vienna Convention on Diplomatic Relations. I will have to double check. So how we did it for the Vienna Convention on Diplomatic Relations is we gave force to certain provisions in the VCDR, but not all. So I will have to double check to see whether that relevant provision relating to reciprocity for the VCDR was put into our statute. But my recollection is that it was not actually. So we will regard it as a matter of our state practice. That will be my question. If I'm wrong, I will ask CIL to find a way to channel it back to you and tell you that I remembered the provision wrongly. It's actually implemented in our domestic law. My recollection is that it's not. Does Singapore adopt a restrictive doctrine when it comes to state immunity? Yes. And does this flow into the international organizations? So actually, the State Immunity Act is quite different and distinct from the International Organizations Act that you are referring to. The International Organizations Act actually refers to privileges and immunities that are accorded to international organizations. So it's quite distinct from state immunity. So hopefully that answers that question. There are two separate sets of privileges and immunities. To the question on, is it so I understand the question to be, what can I do if an illegal act is committed within diplomatic premises? The short answer is that you can't go in because of the inviolability of mission premises. What you will then have to do is you will have to seek the consent of the head of mission to say, look, we believe a crime has been committed, an illegal act has been committed, can we go in to investigate? And without that consent, you can't go in, and then you have to figure out what are the various escalatory steps that you can take at the diplomatic level to try and resolve the issue.
And there was the last here, and you can read it, is from the Philippines, unless Ms. Lorraine would like to ask in person. Otherwise, this is, what are protocols? I guess it's more, are there protocols to prevent abuse? That's how I'm reading it, but
yeah. So yeah, it's a good question. I think I'm not sure exactly what protocols you're referring to, but in terms of at least making sure that both sides have a common understanding and expectation as to how to conduct ourselves, the Ministry of Foreign Affairs does generally share circulars or information in terms of what are our expectations of diplomats and how they should conduct themselves in Singapore. I think maybe that is the sort of protocols that you're referring to, and we do have them in place. And so it's that sort of channel, I think, that really does help for there to be a common understanding between Singapore and foreign missions in Singapore as to how we would like or how we would appreciate them conducting their activities. So that is the sort of protocols we have in place. We have channels, we have circulars that get disseminated from time to time, just to explain like what we are. So for instance, I can give you the case of during the pandemic, when we were going out with all sorts of measures that seemed to limit, let's say, freedom of movement. We actually went out in a very big way to explain to the diplomatic community why there was a need, what were their concerns, how we can address their concerns. And I think in that way, hopefully, once both sides reach a common understanding, then there's less risk of abuse. Yeah.
Thank you, Diane. Any other last question, because we are going a little over time, but Diane has very kindly agreed to stay a little bit longer. Well, I see. Can I just double check for IOs? Its absolute approach when it comes to immunities is the question from Mr. Kyle Loon Low.
Yeah, so thanks, Nala, for international organizations, it would really very much depend on what are the privileges and immunities that has been accorded to that particular international organization. So it's not so much whether it's absolute or restrictive, but it really depends on what are the privileges and immunities. So let's just take the example, in you are a particular IO and that you had come in and we had decided, for instance, for that head of the IO that we will grant diplomatic immunity, because that's the standard that has been given across wherever the IO stations itself in the world. In that case, if you think about that particular head of the IO being granted diplomatic immunity, it is quite absolute. But it's not in the absolute restrictive sense as we understand it for state immunity. Hope that answers the question.
I think it's a great response to this question. Anything else before we bring this excellent session to an end? And just when you're talking about criminal acts, I couldn't help but recall not too long ago on the Saudi consulate, we had the Khashoggi incident.
Yeah,
so that's probably an extreme example.
I considered putting it in, but yeah, I decided not to because it just got me really, really depressed thinking about
Yeah,
it.
I know.
It's
I'm
really
sorry.
solid.
I brought it up, but and I have to say I've been to that consulate in Istanbul, but before the incident, not after.
Okay.
Uh, Patricia, did you have anything you'd like to add? Because I think it's 5 minutes past and we don't want to take too much advantage since Diane has promised to come back. So.
Yes, no, I think that's a great idea, and this area indeed, and I think our participants had that experience already yesterday with Professor Philippa Webb, and they'll continue tomorrow. But the examples you gave from the Singaporean practice just highlight the difficulties that we have sometimes. I mean, they're well entrenched rules in international law, and indeed, I think it's a very proud moment for the International Law Commission that prepared the the draft conventions, both on diplomatic law and on consular law, and I think they're very successful instruments. But there are day-to-day challenges, and indeed, I think the public cares more about these issues than in the past, maybe because they're also more highlighted in the press, and there's a certain sense of injustice. But these rules, they have their reason. And so it's very good to be able to explain to lawyers, but also to non-lawyers, the importance of these rules, but also the particular challenges that they raise. And so I thank you very much, Diane, for being with us today, but perhaps to be continued.
Yes, to be continued, exactly.
Thank
Well,
you.
thank you, and thank you to all the participants again. And tomorrow, our last session for 2024 with Professor Philippa Webb. So we'll see you then. And Diane, happy holidays, Merry Christmas, Happy New Year. And thank you so much for giving us a great ending to our 2023 session of CIL eAcademy Distinguished Speaker Lecture. Thank you so much.
Thank you. Happy holidays, everybody.
Bye-bye.
Happy holidays. And since let me just say 1 minute, I might not be with you tomorrow because I have another meeting. But I just wanted to thank all the participants and all the lecturers and Jerry and the assistants, Teresa, Asla, and also Beryl, for again another wonderful session of the Academy.
We seem to be back with the group. All right, I think
we're still in the group. Yes.
Yeah. We were in all this zooming back and forth. All right, everyone.
See you. Take care. Happy holidays.